Good afternoon, everybody. Good afternoon and welcome. Welcome to our 2024 Fulton Lecture. The Maurice and Muriel Fulton Lectureship in Legal History was created in 1985 by a generous gift from Maurice and Muriel Fulton. Maurice and Muriel Fulton had deep roots at the University of Chicago. Maurice Fulton was a graduate of the college and of the law school, class of 1942. Muriel Fulton was an alumna of the college, and their connections to our university and their dedication and service to the university continued long after their graduations. Maurice was recognized with the University Alumni Service Medal in 2005. Both of them were members of the Harper Society for their generosity to the university. And the Fultons, as I know it, are one of only two couples who are memorialized with a plaque dedicating to their romance here in Hyde Park. I think if you go over right outside on the main quadrangle near Swift Hall, there is a plaque right where they met on campus. And if you're wondering, well, who's the other couple who has a plaque in Hyde Park? I believe it is the Obamas up on 53rd Street by the Baskin-Robbins. So that's rare company. The University of Chicago has, of course, from its inception, advanced and celebrated the interdisciplinary study of law. And indeed, in our very first year as a law school, we encourage students who are coming from our college to the law school to take courses in legal history because, as we told them then, instruction in and knowledge of history is of special value and of interest to any future lawyer. And in particular, our students were encouraged to take courses in the constitutional and political history of England and the constitutional and political history of the United States. And the Fulton Lecture continues this tradition and celebration of legal history by bringing to us a prominent lecture by a leading legal historian. In recent years, the Fulton Lecture has explored topics such as the influence of propaganda in civil liberties in World War I, the impact of Presidents Johnson and Nixon on the contemporary Supreme Court. And I'm thrilled today we're going to add to this distinguished legacy. We'll do so with one of our own, Professor Alison LaCroix. Professor LaCroix is the Robert Newton Reed Professor of Law and an associate member of the Department of History here at the university. She is a scholar of U.S. legal history, and she specializes in constitutional law, federalism, and 18th and 19th century legal thought. She is the author of numerous books and articles. Her latest book, The Interbellum Constitution, Union, Commerce, and Slavery in the Age of Federalisms, will be published later this month. It's exciting to have an advance copy. You can't have it, it's mine. The book examines the constitutional law in the period of 1815 through 1861. This is a period of constitutional development that's long been neglected or wrongly dismissed as uneventful. Professor LaCroix synthesizes the legal, political, and social history to show how the post-founding generation was forced to rethink the U.S. constitutional vision. And the book is already attracting enthusiastic praise. For example, Professor Jill Lepore of Harvard, who spoke here earlier in the quarter, calls it pioneering and essential reading. Another prominent legal historian calls it brilliant, prodigiously researched, bristling with startling revisionist arguments, by far and away the best account of the roiling world of American federalism in the crucial decades between the War of 1812 and the Civil War. Having read advanced chapters myself, I know what a blockbuster this book is going to be, and I'm thrilled Professor LaCroix is here to give us a sneak preview today in the Fulton Lecture. Professor LaCroix received her BA and her JD from Yale, her PhD in history from Harvard. Before joining our faculty, she practiced as a litigator at a leading firm in New York and held the prestigious Gottlieb Fellowship in Legal History at NYU. As a member of our faculty, she's taught constitutional law 1, civil procedure, federal courts, American legal history, among other subjects. And students, many of whom I'm glad to see here today, consistently and enthusiastically praise Professor LaCroix's teaching, and her courses draw very large enrollments. For example, I saw on one teaching evaluation, one student wrote, "Professor LaCroix is a con law icon." Students consistently praise her ability to make dense material clear. One student advised everyone should take a class from Professor LaCroix before graduating. And then I think there's this one, which is perhaps the highest praise. I thought I would hate civil procedure, but Professor LaCroix made me love it. In addition to her amazing teaching, Professor LaCroix's scholarship has been awarded a fellowship from the National Endowment for the Humanities. She has been for many years a co-editor of leading journals in the field, such as the American Journal of Legal History. In 2021, she served on the bipartisan Presidential Commission on the Future of the Supreme Court of the United States. I am thrilled that she is our speaker today. She will take questions at the end of her presentation, so I particularly encourage our students to prepare their questions. Please join me in welcoming our 2024 Fulton Lecturer, Professor Alison LaCroix.
Thank you very much, Dean Miles, for that generous introduction. And thank you also to the Fulton family for their generous endowment of the Fulton Lecture Series, one of the signal events celebrating legal history here at the University of Chicago. And thank you also to Casey Rosen, Quinn Barron, and the events team here at the University of Chicago for organizing today's lecture and filming. I'm delighted to be here today to talk a bit about how the United States became the federal union that we know today, and to bring back into the spotlight this period that has tended to be absent from constitutional history, the period between the founding era and the Civil War. My new book, The Interbellum Constitution, Union, Commerce, and Slavery in the Age of Federalisms, focuses on the decades between 1815 and 1861. The book argues that this period was the origin point of much of what we now think of as modern constitutional law, especially with respect to the relationships among levels of government, what we now call federalism. But this isn't only a story about legal doctrine, and it's not only a historical account. That's because in this period, we also find the seeds of many of our current political and legal debates and struggles. From controversies over who governs at the southern border, to the regulation of abortion, to voting rights, firearms, healthcare, and immigration, to name just a few, the issues at the center of public debate right now have their roots in this interbellum period. All these controversies involve questions about federalism, which level of government is to govern given our system of multiple levels of authority. The interbellum period laid out much of the federalism landscape that we now know. The landscape was formed from many sources: constitutional structure, doctrine, practice, and text. It was also shaped by debate in courtrooms, in Congress, but also in the public square. One of the central arguments in the book is that constitutional law itself was changing in this period. There was, in short, an interbellum constitution. And the principal intellectual and doctrinal terrain on which it took shape was on the question of union. In these remarks, I'll begin by sketching the book's central argument and its main themes. Then I'll move to discussing a set of core episodes that form the heart of the book, the geographic center in the overall map of chapters, and the substantive and methodological nucleus in the body of the book. So first I'll begin with the argument. What is this book about? And what do I mean by the phrase, the interbellum constitution? The subject of the book is the nature of the American Union between 1815 and 1861, a 46-year period, not very long, that was bordered on both sides by war. The War of 1812, which ended in 1815, and the Civil War, which began in 1861. I argue that we must change our view of those decades, and in particular of the legal and political debates that took place within them. In arguing for the significance of the interbellum constitution, the book makes 5 principal arguments. The first is that the interbellum decades constituted a distinct period. Historians love to talk about periodization. Well, the first argument is one of periodization. This is a period. For too long, the early 19th century has been treated as simply a gap or a hiatus, flyover country, as I like to think of it, between the real moments of constitutional change, the founding era and Reconstruction. Instead, I argue that this period is a distinct era in which things were changing, different from before and different from what came after. The interbellum constitution was a set of widely shared but contested legal and political principles, combined with a thoroughgoing commitment to investing those principles with meaning through debate. The principles were commerce, concurrent power, and jurisdictional multiplicity, federalism, all of which were frequently grouped by contemporaries under the heading of commercial union. The debates took place in many arenas: newspapers, private letters, legislative chambers, and of course the courtroom, which included the arguments of lawyers as well as the opinions of judges. Even though the text of the Constitution did not change during this period, no amendments between 1804 and 1865, constitutional meaning was changing. The book's focus is constitutional and political debates about what we would now call federalism, but that word doesn't entirely capture what I call the landscape of constitutional discourse in this early 19th century period. And here's where the second of the book's arguments comes in. I argued that there were many distinct federalisms, plural, during the interbellum period. That S is not a typo. These were not our modern day versions of federalism as a contest between the center and the states. So I reject a pair of conventional stories about how we tend to think of federalism. One is what we might call the binary federalism account, which frames all disputes in American structural constitutional law as contests about the power of the general government versus the states. According to this view, the main feature of the antebellum period was that it was the point of origin for the great contest between states' rights and the Union that, of course, culminated in the Civil War. In the early 19th century, however, roiling contests among many levels of government swept from the realm of foreign relations, including those with native nations, to the president's cabinet, to Congress, to state legislatures, to governors, to county sheriffs, to city harbor masters. If we look to this period only to find the origin of the conflict between the Union and states' rights, we risk committing what the great intellectual historian Quentin Skinner calls the mythology of prolepsis, also known as reading history backward. Skinner writes, such confusions arise most readily when the historian is more interested in the retrospective significance of a given historical work or action than in its meaning for the agent himself. One sure symptom of the mythology of prolepsis is when an argument about a past moment, say the nullification crisis of 1832, relies on later events to give it meaning. Or as Skinner puts it, the action has to await the future to await its meaning. When 1832 is read as mere prelude to the Civil War, 30 years later, we are squarely in the land of this mythology. The other conventional account of federalism that I challenge follows from this. This one concerns the valence of each power in the federal-state dyad. According to this view, again very much shaped by the Civil War and Reconstruction, the tendency of federal power was toward liberty, freedom, and in particular, limits on slavery, or indeed emancipation and abolition of slavery. State power, meanwhile, in its many incarnations, is seen as tending toward, and perhaps even necessarily tied to, protections for slavery, limits on freedom, in particular the freedom of Black people. Because the era has typically been viewed through this lens of the impending crisis and the irrepressible conflict of the Civil War, the federal state alignments of the 1860s and beyond have frequently been read in reverse, projected onto the early 19th century. As I try to demonstrate in the book, however, the valence of federal power in this interbellum period did not necessarily orient toward freedom, and the embrace of state authority did not always serve subordination. Indeed, for much of the period, the federal government was controlled by the slaveholding South, and federal power enforced such measures as the Fugitive Slave Acts and the Indian Removal Act. Third, the book argues that ideas of concurrent power were central to interbellum constitutional discourse. This embrace of concurrence sets the period apart from both the founding and the Civil War and the Reconstruction era. Concurrent power had been one of the great unsettled questions in the Constitution of 1787. The federal government had enumerated powers, to be sure, but were they exclusively federal? Were they shared with the states? How was this division to be demarcated? It just wasn't clear from the Constitution. Early 19th century Americans were consumed by arguments about concurrent power. After 1815, most of the pressing legal and political debates concerned the domains in which concurrent power was debated: commerce, migration, and slavery. Importantly, arguments for concurrent power were distinct from arguments for state power itself. The fourth claim concerns a core element of modern constitutional law, the federal commerce power. In practical terms, commerce was the primary crucible in which interbellum struggles over federalism boiled. In terms of constitutional structure, the commerce clauses of Article I were the doctrinal vessel into which these conflicts were poured, and which in turn shaped their resolution. The interbellum period witnessed a burst of intellectual ferment and conflict over the nature and scope of Congress's power to regulate commerce among the states, with foreign nations, and with native nations. The fifth claim concerns union, both the Union, capital U, in the sense of the American Federal Republic, as well as lowercase u union in a more general and theoretical sense. The book highlights the many and varied meanings of the concept of union in this period. Sometimes contemporary commentators invoked a substantive vision of the union. For example, the argument that the commerce power was a tool to foster something called the commerce of the union, which was central to many great Supreme Court cases, including Gibbons versus Ogden, decided in 1824. Sometimes theorists invoked union as a talisman of unity and national purpose to rebut claims of local power. In other instances, union was more of a stand-in notion, an agreement to defer difficult and divisive political choices in favor of compromise. This use of union concepts was thinner, and it was felt to be so by many contemporaries. Indeed, by the 1850s, critics of this rhetoric of union were demanding more. They asked what the purpose of the union was, expressing dissatisfaction with what seemed to them to be tautological views that assumed the union existed, that it could be maintained, and that it was worth preserving. The emotional, moral, and constitutional heft of the phrase the union was, like so much else in this period, contested and fragile. Amidst these upheavals, interbellum Americans exhibited an adolescent mix of bravado and anxiety, very unpredictable. They sometimes viewed themselves as cast adrift as they watched the members of the founding generation die in the 1820s and 1830s. At the same time, interbellum legal thinkers were enormously creative and quite bold in asserting how creative they were. They were not the passive heirs of the founding, nor were they mere implementers or liquidators of an already fixed constitutional meaning. This creativity becomes apparent when we expand our study of interlocutors beyond the usual suspects, the usual candidates. And in the book, I broaden the range of interlocutors to include a group of thinkers whom I call producers of constitutional discourse, and I'll talk about two of them today. These thinkers believed that duty required them to be faithful heirs of the founding generation. Fulfilling this charge required reverence for what Abraham Lincoln in 1838 called the political religion of the nation's founding charters. Yet these interbellum constitutional thinkers rarely appeared to feel confined by the actual text of the Constitution. William Wirt, Maria Henrietta Pinckney, Frederick Douglass, John Marshall, John Ross, Elias Boudinot, Daniel Webster, William Johnson, John C. Calhoun, many others, these producers of constitutional discourse understood themselves as obliged to honor the structure of the Constitution in some ways. They were committed to constitutional interpretation through argumentation, spoken as well as written. So now I'd like to turn to a set of core episodes in the book, 2 chapters. They concern South Carolina in the 1820s and 1830s, but they are not the usual stories of South Carolina in this period or South Carolina in, say, 1861 at the beginning of the Civil War, nor do they focus on the usual South Carolinians of the period. These episodes concern 2 searing moments of legal and political controversy that began in Charleston but reverberated throughout the nation and across the Atlantic. So here we see an image of Charleston in 1776. And as this print suggests, the city was the creature of its enormous harbor, the point at which the Ashley and the Cooper rivers opened into the Atlantic Ocean. By the 1820s, the waters were still the highway connecting the port to trade and commerce, both interstate and international. But in the eyes of some South Carolinians, the harbor was increasingly a moat of autonomy, surrounding what they saw as a bastion of state power. Given the city's long history as a center of first imperial and then national exchange, claims that local authorities should control not only the city but the waters around it collided in this period with equally powerful assertions of authority from the federal government. These 2 episodes involve a pair of leading, but for different reasons, largely forgotten or ignored Charlestonians. The first of these was Justice William Johnson, Jr., Supreme Court Justice from 1804 until his death in 1834. Johnson was nominated by Thomas Jefferson to serve on the court as a Republican bulwark to Chief Justice Marshall. But Johnson ended up becoming the voice and vector of federal power against his fellow members of the Carolina planter elite. And he also dissented, in many cases, from Marshall, as Jefferson had hoped, but not exactly in the direction that Jefferson hoped he would. And as we'll see, in 1823, when sitting as a circuit court judge, riding circuit as Supreme Court justices did in those days, Johnson issued a decision that was the first time in which a federal judge found that a state law violated the Commerce Clause of the Constitution. The decision spawned a backlash in Charleston, cries of nullification 9 years before the Nullification Declaration of 1832, threats against Johnson. Johnson was deeply of Charleston, as we'll see, but this is not a typical account of what Charleston usually witnessed or stood for in the 1820s and 1830s. Our second Charlestonian is Maria Henrietta Pinckney, born in 1774, died in 1836. No portrait of her survives, but her writings do. This is the cover page of one of her pamphlets, The Quintessence of Long Speeches, a Political Catechism by a Lady for Her Goddaughter. Pinckney was the daughter and niece of revolutionary generals who were also drafters and ratifiers of the Constitution. Plenty of portraits of them. She was described by her family as a woman of masculine intellect, a wonderful appellation. She was a writer, she was a planter in her own right, she was a slave owner in her own right, she was a leading theorist and strategist of the nullification movement. Her male cousins served in the South Carolina Nullification Convention in 1832, but it was the Pinckney mansion, at this point owned by Maria Henrietta Pinckney and her sister, that nullificationist leaders sought for the backdrop of their parades and public ceremonies. And it was Maria Henrietta's defense of nullification, the Political Catechism, that became one of the core documents of the movement. When she died in 1836 at age 62, the Charleston Mercury, edited by another Pinckney, a distant cousin, carried a notice directed to the states' rights men of 1834 that lauded her heroic patriotism, the strength of her bright character, and the tributes of her cultivated intellect. So let us begin with Justice Johnson. Our first episode took place in August of 1823. The setting was the courthouse in Charleston at the corner of Broad and Meeting Streets. It's still there. And on the bench that day in the second floor courtroom, it was August in Charleston, we can only assume it was sweltering, was Justice Johnson riding circuit and sitting before a courtroom packed with onlookers. Johnson was hearing a case in which a free Black British sailor named Henry Alison was challenging a South Carolina law that required that any free Black sailor debarking from a vessel in any South Carolina port be immediately jailed for the duration of his vessel's stay. The battle over this law, known as the Police Bill or the Seamen's Act, involved numerous levels of governmental and non-governmental actors, each with its own views concerning the constitutionality of the state regulations. Officials involved in these debates, showing that this again was not simply a federal versus state dichotomy, officials involved included United States Secretary of State John Quincy Adams, U.S. Attorney General William Wirt, British ministers in London, British consuls in Charleston, the South Carolina congressional delegation, and local officials such as the sheriff, one Francis G. DeLisaline. As sheriff, DeLisaline was responsible for carrying out and enforcing the police bill. He was the county sheriff, he was the local official. He seized and confined Alison along with many other sailors when this law was in force. Alison, however, brought suit. Now, Alcison's case was not entirely unique. Other Black sailors also sought to challenge their confinement. But one major difference set apart Alcison's case, and that was that the British government supported and helped to fund his suit. They helped him find lawyers who brought his case before the Federal Circuit Court, not the state court, significantly, and over the Federal Circuit Court presided Justice Johnson. Meanwhile, one might wonder who was defending the state statute, who was carrying out the prosecution of Henry Alison. Interestingly, not the state of South Carolina. Justice Johnson's opinion, which ranges widely in giving us the background of the case, far beyond what was really required to dispose of the matter before him, tells us that the Attorney General of South Carolina declined to appear to defend the act or the detention of Alison. Instead, the South Carolina Police Bill was defended by a private group, a newly formed entity called the South Carolina Association. The association was a private organization of slaveholders who made it their mission, as their announcement in a local newspaper put it, to aid the execution of the laws founded upon the local and peculiar policy of South Carolina. The association had been formed in response to events in June of 1822, when residents of Charleston were reeling from the news of an alleged conspiracy among the city's enslaved population, led by a freedman named Denmark Vesey. The members of the association included many of the leading members of Charleston's planter elite, including General Thomas Pinckney, Maria Henrietta Pinckney's uncle. Thus, it was the association's lawyers who appeared in Johnson's courtroom, not the state, to argue on behalf of the South Carolina police bill. Johnson, in his opinion, held that the South Carolina statute unconstitutionally interfered with the federal government's right, as he put it, to regulate interstate and foreign commerce. The constitutional issues, Johnson said, involved the police bill violating both the federal commerce power and the federal treaty power. He rejected the association's argument that the statute represented a valid exercise of South Carolina's power to regulate foreign and interstate commerce, which it shared with the federal government. Here, Johnson said, federal law made it lawful for this seaman to come into this port in this vessel, and for the captain to bring him in the capacity of a seaman. These, Johnson maintained, are the very acts for which the state law imposes these heavy penalties. Is there no clashing in this? It is in effect a repeal of the laws of the United States, converting a right into a crime. Johnson thus rejected the South Carolina Association's argument that the police bill represented just a regular use of the state's police powers. On the contrary, Justice Johnson held it was an effort to divest a right conferred by the general government. The key for Johnson was the fact that the South Carolina law clashed with federal power over interstate and international trade. And again, here the involvement of the British government is illustrative. British merchants strongly objected to these sorts of laws. And this was evident in the way Johnson presented his opinion when he published it as a pamphlet, in part because he couldn't have it published by the usual channels because there was so much resistance to his opinion. So as you can perhaps see in these two pamphlets, on the left, we have Johnson's opinion, which he paid to have published and distributed. And the case is described as ex parte Henry Elkison, a subject of His Britannic Majesty, really putting front and center the fact that this South Carolina law was an imposition against federal and international trade. We can contrast this with the competing account of some of the arguments published also in pamphlet form by one of the lawyers for the South Carolina Association, ex parte Henry Elkison, claiming to be a subject of His Britannic Majesty. So Johnson was a fascinating character, and in this case, as in many others, had a tremendous influence on US constitutional law. And part of his impetus for deciding the case the way he did involved his own legacy and legacies in Charleston itself. He was the son of parents who had both participated in the Revolution, his father in the Continental Artillery, his mother smuggling cartridges to him in her petticoats. He was a slaveholder, he was a planter. He was on the Supreme Court, and on occasion he was more nationalistic than even Chief Justice Marshall. So traditional stories about the Marshall Court and Marshall's dominance of the court tend to leave Johnson out, but what's equally important here is the way that Johnson represented this Charleston legacy and South Carolina legacy of a combination of embrace of federal power and resistance to entities like the South Carolina Association, even as he himself enslaved people and was a planter. Interestingly also, as a young man, Johnson had read law with Charles Cotesworth Pinckney, the father of Maria Henrietta Pinckney, and Maria Henrietta was William Johnson's almost exact contemporary. In the course of his studies with General Pinckney, Johnson was a frequent visitor to the Pinckney Mansion, an imposing building on East Bay Street in Charleston. In the densely populated environment of early 19th century Charleston, the Pinckney Mansion lay just a few blocks from Johnson's house and his father's blacksmith shop. So here we see an image, a map of Charleston from 1855, and this is a close-up that shows that just a few blocks away from Johnson's house on the top left was the Pinckney Mansion on the bottom right. But they were very different types of structures. And the Pinckney Mansion is at the center of understanding Maria Henrietta Pinckney's life and work as well. So let us turn now to looking at Maria Henrietta Pinckney in the second episode. So as I mentioned, Pinckney was the daughter of a famed patriot, Revolutionary general, and later vice presidential candidate, Charles Cotesworth Pinckney. Here's one of many portraits of Charles Cotesworth Pinckney, Federalist Party candidate for vice president in the contested election of 1800. He came very close. Maria Henrietta Pinckney never married. After her father's death in 1825, she and her sisters inherited the mansion on East Bay Street, as well as several plantations and more than 200 enslaved people. In 1830, Maria Henrietta Pinckney announced herself publicly as a nullifier. She wrote and published a closely argued treatise to explain why. And this was the Political Catechism. In 1830, she published the 24-page pamphlet, The Quintessence of Long Speeches, arranged as a political catechism by a lady for her goddaughter, a great, long, compound 19th century title. The use of the catechism term here was deliberate. Religious instruction was the province of women, especially upper class or upper middle class white Protestant women. But this was a different kind of catechism, as becomes very clear if you read the question and answer format. It's not about what is the nature of God or what is the nature of the Trinity. It is what is the nature of the federal Constitution and what does one think of Mr. Webster and his arguments in the Supreme Court. The Political Catechism was published in 1830 in the heart of the nullification crisis of 1828 to 1833, and it laid out a number of forceful arguments. First, the Union was a compact of the states. It wasn't a government formed by the people at large, contra, say, the Supreme Court in McCulloch versus Maryland. Pinckney also offered a strong critique of the court in terms, especially its nationalism and especially its claims to be an umpire. Pinckney said there was no such umpire over the federal system, and it was preposterous to think that the court could have such power. She endorsed a radical view of the sovereignty of the states, saying, state means the people in their political capacity and never their government. Her reading of the preamble of the Constitution is also striking. Not of the United States, she said, but of the states, comma, united. Pinckney's treatise was even more radical than the more famous tract by her friend, John C. Calhoun, the famed theorist of nullification, whose Fort Hill address issued a few months after Pinckney drafted her political catechism. Pinckney's was a political tract couched in terms of a catechism delivered to a young female relative, and there was a young female relative. It was a cousin kind of in-law. So she was indeed addressing this to a female relative, but it was also addressed to the wider world. And Pinckney's activities were not confined to writing. She planned to import a cargo of sugar with the governor of South Carolina in order to test the federal tariff laws. She and her sister Harriet called their mansion Nullification Castle, and it was reported as such in the press. They leased office space to their political allies in the state rights party, and they participated in political parades, albeit on their own terms. For instance, when the State Rights and Free Trade Party held a celebration on July 4th, 1831, July 4th was always a big day for these sorts of celebrations, the Pinckney sisters demanded that a banner be presented to the procession in the name of the state right ladies from the late residence of a distinguished patriot, but declined themselves to be participating in the parade and to be standing up on the rostrum with other members of the procession. And in the same procession, the case of Elkison versus DeLisaline, which Justice Johnson had decided 9 years before, was invoked by name by South Carolina politicians as a precedent for their time-honored practice of nullifying federal law. And all of this was happening from the Pinckney mansion. Here's our 1776 picture of Charleston again. Circled over to the right is identifiably the Pinckney mansion, and here's an enlarged picture. The mansion, as you can tell from this seascape, was a piece of the landscape of Charleston from the Revolutionary through the antebellum periods. And the mansion itself was a connection between these episodes in the persons of William Johnson and Maria Henrietta Pinckney. The study in which Johnson learned law from Charles Cotesworth Pinckney what was very close to and might have been the same room as the library in which Maria Henrietta Pinckney read her father's law books, consumed works of political theory, and penned her political catechism. It was the locus of different but equally powerful revolutionary legacies for these two scions of Charleston families. And it produced dramatically different views of the relationship among levels of government in the interbellum United States. So what became of the mansion? Well, in 1861, December, the 8th month of the Civil War, it was destroyed in the Great Charleston Fire. The cause of the fire always lingered somewhat mysterious. It was likely an accident combined through the concatenation of high wind, textiles stored in warehouses, and sparks. At the time, contemporaries in Charleston rumored that the cause had been either insurrection by enslaved people or the Union gunboats that were moored in the harbor blockading it. They did indeed fire a salute during the conflagration, but they weren't responsible for the fire. But this is the mansion as it appeared in 1861, when it was depicted in many images of the ruined South and the ruins in cities of South Carolina in particular. So what does examining these episodes from Charleston in the 1820s and 1830s tell us about the many varieties of interbellum federalisms? And what do we learn about the Interbellum Constitution from the careers of Pinckney and Johnson? First, these episodes tell a story of local power and local connections in a period in which local dominance was itself contested. Who was the real Charlestonian who could speak for the city? Maria Henrietta Pinckney or William Johnson? Charleston was a city obsessed with familial and political connections. How did local power, both formal and informal, interact with the many layers above it, state, national, and international? Second, these events delineate the multiple strands of what I call the long founding moment, which both Johnson and Pinckney explicitly claimed for themselves. They were simultaneously products and producers of the long founding moment. Johnson famously went around Charleston trying to locate the location of the Liberty Tree from the Revolutionary period to dig up the roots in order to send them to Thomas Jefferson. Both Pinckney and Johnson had access to the world of politics through storied family connections, and both used that legacy as a source of rhetorical power. Both understood themselves to be living in dialogue with revolutionary forebears. The meaning of that legacy informed each of their lives, but the lessons they drew from this shared inheritance could not have been more different. The substantive divergence of their views on the nature of the Union is tremendously striking. Pinckney's views shaped the nullificationist platform. Her defense of states' rights and her attack on federal power were more vigorous than those of her more famed, and it must be said, male contemporaries. Johnson, meanwhile, offered full-throated endorsements of national power in a way that was startling to his contemporaries and remains so today. So what did what we would now call federalism look like in South Carolina in the 1820s and 30s? It comprised multiple levels of government. It potentially entailed alternatives as diverse as exclusive federal power over commerce or state power to nullify federal law. It was very parochial in some ways, and it was highly nationalistic in others. And it insisted on every punctilio of respect for the state's revolutionary heritage. It was indeed both Johnson and Pinckney. So in conclusion, why does this sort of tale matter for our understanding of federalism? First, in order to have a complete understanding of US constitutional law today and historically, it's imperative not to lose sight of the constitutional creativity of these decades, between the big stories of the founding period and the Civil War and Reconstruction. During this half-century, the interbellum period, the central public debates in America centered on issues that raised profound federalism questions: commerce, migration, and slavery, among others. Second, the period reminds us that the meaning of the Constitution was not settled or fixed in 1787. Important and unsettled questions were being debated for the next decades, and indeed today. The best way to gain purchase on these meanings is to attend to these debates. To understand what the Constitution meant at a given time, one must listen to producers of constitutional discourse. Their statements not only provide evidence of meaning, they were speech acts in which meaning was created. Examining the debates in this way affords a broad view of the landscape of constitutional possibility at a particular moment in time. And finally, the period is important because it helps give context to our own moment of intense political and legal debate. Many commentators cite the Civil War as an analogy to and a cautionary tale for the current moment. But the most accurate benchmark is not the war itself. It's the 5 decades of simmering constitutional conflict that preceded the war's outbreak. The similarities between those years and today provide context, insight, and perhaps a warning to us all. On the eve of the Civil War, President Lincoln proclaimed in his first inaugural address that the union of these states is perpetual. But he might as well have added, conflict about the structure of the Union is perpetual. For so it has been ever since the Constitution's drafters laid down their pens in 1787. Thank you. And now I'm happy to take questions. I welcome them. And I think the dean has told me I can call on people, so that's very exciting. Yes, Professor Helmholtz.
Are there any European models that were used to try to deal with some of these perpetual problems?
About conflicting levels of government?
Yeah.
Yes, I mean, one of the things I find most interesting about this is especially when we look in the executive branch, so the president or the secretary of state or other members of the cabinet, the attorney general, you actually find them sitting there debating issues that are US-based issues about what states or local governments can do or how to respond to crises. And they pull off the shelf works of continental political theory and British political theory. So there's this great exchange where Secretary of State John Quincy Adams and Attorney General William Wirt are sitting there talking about a question that's been put to them by President Monroe, and they get down their volumes of Pufendorf, Montesquieu, they're thinking also about the politics of it. So they think of it as something where they have to think about the politics, they have to think about the United States Constitution and who has power and the separation of powers, but then they also rely on theory in a way that I think we find very striking, especially law of nations theorists. And so that's, I think, one of the big ways that we see a European influence.
What were the lessons that emerged from that?
Well, I think one lesson was they said, there were instances where they said, for instance, how do we think about belligerent nations' rights? So a lot of these cases involved shipping or trade and seaborne traffic. And so one of the perpetual issues in the period was about neutrality, recognizing neutrality and dealing with nations as neutrals. And so they would look to the law of nations for sort of principles, at least, about how to deal with the law of nations. That said, then they would have discussions that we would today, I think, read as very much historical gloss-ish, a la later. So we can't say that that's what they were doing, but 1950s style, kind of Youngstown historical gloss, where they would say things like, well, in the past, presidents have settled these issues in the following way, with or without acts of Congress. So it was kind of a mix of law of nations theory, but also practice. Well, yes, Professor Fennell.
So I wanted to hear a little bit more. I guess I was curious about the localism angle, the idea of city power and how that interacts with what's happening with the other layers of government. And it seems to me that, and I may be wrong, of course, but it seems to me that the commerce part of this might often be very tied to particular cities more so than to states at large. If there are particular cities that are more immersed in commerce, or that are port cities or whatever.
Yeah.
So I guess I'm just curious to hear a little more about that.
Well, yeah, I mean, and there is this pervasive theme, I would say, in the book and in the period about the layers of port regulation and how the ports are themselves the kind of locus where a lot of these debates happen. Now, one reason is because in most ports you would have, it's a site where you would have federal governmental power. Like that's one of the few places that there are federal officials, like revenue and customs people who are collecting federal funds. But you would also have state and local officials all there kind of doing their thing, going through counting the hogsheads of Madeira and all sorts of other things and issuing their paperwork. But you would then have just this concatenation of different officials. Like a ship comes into a port and the federal officials are saying, well, we're concerned about whether you violated some federal act, and the state officials sort of don't care as much about that. But they're all there kind of acting as governmental sort of executive officials, I think, in an interesting way that we often think is not occurring in this period. And then there's also a separate dynamic afoot, which is you have a number of states, and this is true in South Carolina, but it's not only a Southern phenomenon, it's also New York, it's also various other states where the state capital is not the major port city. And so this happens in Charleston, Baltimore, New York, where you have the state laws that are being passed that have something to do with, say, in South Carolina, the jailing of black sailors, or in New York, Albany says, you need to have these sort of licenses filled out, or Baltimore to Annapolis. And the port, the kind of local commercial elite in the port city feel very aggrieved by this and often end up making arguments that are more pro-federal power because they feel like the capital doesn't get it. And they feel like the capital doesn't understand their interests as a port city. And they are also just more cosmopolitan because they're a port city with much more interaction with trade more broadly. So that's another aspect of the federalism story that I think is interesting. Intra-state conflict between the capital and the port city. And in many cases, the port city is much older too. And that's certainly true with Charleston. Yes, Professor Slaughter.
This is wonderful, and it's a revelation to think about this moment from the perspective of Justice Johnson or from Henrietta Pinckney. Have we just been suffering from those sins of prolepsis by focusing attention on, say, Robert Hayne or John Calhoun? In other words, can you tell the story of this moment of the nullification crisis without those actors?
Without Hayne and Calhoun, I think you can't tell it without them, but they need to be put in context with a lot of others. Well, they're in the background. They're peripheral, but they're not the whole story. I mean, I think there's a way in which, like Johnson to me is so interesting because he highlights how you can have someone who very much in terms of his mentality is part of the planter elite. Now, he had a little bit of a chip on his shoulder, I think, because he wasn't at the level of the Pinckneys and the other real aristocrats. But that said, I mean, he thinks he's just as much of a claimant to the South Carolina legacy of the Revolutionary period as any of those others. And so I think we've tended to, Calhoun and other people stand so much for what nullification is in this there's one view of states' rights, and this is what it is, and it is contra the federal government. Whereas Johnson, who in other cases was, again, someone who was very much allied with lots of things that Calhoun probably stood for, was also someone who was kind of much more pro-federal power. So it complicates the story about all the South Carolina nullifiers are always anti-federal power, and that it proceeds from this set of particular political and socioeconomic affiliations. I mean, I think Johnson is a great example because he's not the only one, because he basically says, look, you're misunderstanding the whole nature of the federal and international commerce power. So I don't think you can tell it without them, but I think we've told it too much only through them. And then Pinckney, I think, just adds a whole other dimension, because usually when we think of kind of women who are political or social reformers or political thinkers writing in this period in that kind of environment, generally it's a pretty small denominator, but it tends to be like the Grimke sisters and others who are critics of slavery, who are women's rights advocates. And here's Pinckney doing something quite different, which I think also adds a lot to our sense of the many strands that are operating here. Yes, Professor Boat.
So I may be overly influenced by your first book, but is there also a federal jurisdiction angle to these debates? So it's hard to see
always
the
a federal
jurisdiction. It's hard to see the pictures of the port. So the question of is the port national or local?
Right.
Without thinking about admiralty jurisdiction, of course.
Yes.
Like the decision to give federal courts admiralty jurisdiction. Does that weigh in the federal government's favor? Is that somehow separate from these fights?
Well, it's interesting. So yes, I mean, there are some of these cases, like there's a case in one of the other chapters that I talk about that's another Commerce Clause before you get to the Supreme Court case that's Chief Justice Marshall writing circuit. And that is more of an admiralty case. It's kind of a proceeding against a ship where the owners have in various ways violated federal revenue laws. But one of the things that I think makes the Elkison versus DeLisaline case notable, and it's not unique in this, is that instead of it coming to the federal courts through admiralty jurisdiction, it's not admiralty. I mean, it's sort of unclear what it is, and it's clear that Johnson was heavily involved in trying to get the case before him, and he was politically negotiating with people behind the scenes. But the nominal basis of federal jurisdiction is this kind of amorphous set of challenges to confinement. There are two different writs, habeas corpus and writ de homine replegiando. And what is the basis of the jurisdiction? Well, it's probably those things, but it's not admiralty. It's not about the ships. So yes, I mean, it's certainly the case that I would say that there's a sort of prior cause to admiralty jurisdiction and to a lot of this, which is a sense that they really believe in a robust, especially international, but also interstate commerce power. And you go back to even the Articles of Confederation or Locke's second treatise, the federative power is one of the few things that people think the British Empire should have, for instance, and one of the reasons is because it has to do with trade. So I think, yes, there's a federal jurisdiction angle. There's a lot of shenanigans with federal jurisdiction. And then there's Johnson and others, and other chapters talk about other justices and judges. There's a lot of shenaniganery, I would say, chicanery, probably better, where constitutional issues just all of a sudden appear on the record, and a court's been dealing with a case for like years, and all of a sudden someone says, well, maybe there's a Commerce Clause issue, and boom, it gets reviewed by the Supreme Court. So there's a fair amount of litigation kind of awareness of the political and legal changing terrain also. Yes, Isaac.
I was curious,
how much rhetorical space is there for like frank discussion of liquidation in this kind of long founding moment? Like, how much are people willing to say, like, you know, it is kind of open what X, Y, or Z rule is going to be right now, and we kind of just need to fight for the one that we think makes sense, versus a, you know, debate over like, no, this is really just what the structure is, or, you know, this is what the document really is, and, you know, other people are just wrong.
Yeah, I would say there's both. I mean, sometimes there's a self-conscious sense from the contemporaries that we are now setting a rule, or we have been handed something that doesn't answer this particular crisis that awaits us, so we're going to have to figure it out. And that's where you see, I think, the kind of the bravado mixed with the insecurity. Like, one minute they're sort of like, of course we can do this, no problem. And the next minute there's this sense of, well, we better not mess it up. And so I think of Lincoln in that Lyceum speech in 1838, you know, where he's saying, well, look, first of all, we don't want mobs and mobocracy. And he's really emphasizing anti-abolition lynch mobs, especially. So destroying printing presses from abolitionist editors and so forth. But he includes lots of different kinds of mobs. And he says, you know, the one thing we do have is the Constitution and the Declaration. And he doesn't really flesh out what he means by that, except to say, this is the political religion of our nation. So it's almost like, well, we all have to agree that we have those and that those things are the benchmark and that anything else is kind of suspect because anything else might be the mob. And now there's this whole overtone also of we all miss the big events and it's very sad for us because our job is just going to be this very, you know, kind of small bore conservation of the founding. And sorry, everybody in Springfield in 1838, you know, just hold fast. And it's like, it's Abraham Lincoln, it's 1838. He doesn't know what's coming. Mythology of prolepsis. But I think that's part of it. Like, there's a sort of underspecified sense, but they are increasingly kind of anchoring to this notion of the Constitution, which itself is not necessary. Like, even the fact that someone like Lincoln sort of says, we have all these disagreements, but we have the Constitution, is sort of, to us, something that seems natural. Like, what else would they grab onto? But that was actually something that we see occurring in this period. I think I saw another. Oh, yes, Professor Strauss.
One character who I think is conventionally thought to be a prominent figure in your period, but you de-emphasize him, is Andrew Jackson. Now, is that just another example of reading history backward, that people jumped on Jackson to justify the New Deal coalition? Or was he actually, you know, was he actually not that significant? Or is there other stuff going on that's more Jacksonian than, you know, what you just described?
He's definitely in the book. So yeah, I mean, I think one of my arguments is, yes, this isn't the age of Jackson. I mean, that is a sort of sobriquet that still this period gets, kind of for lack of others in some ways. So he's clearly very important, and he's important in different ways. I mean, he's important, first of all, he's there in 1815, which, being the hero of New Orleans, in ways that I think put into play his presidential campaign in 1824 when he ends up losing, and in 1828 when he sweeps into power. And so he's kind of there throughout part of the book as a kind of background figure, but very much emphasizing this coming out of the War of 1812 sort of American nationalism in a military sense. I mean, and I would even connect it to Chief Justice Marshall in McCulloch versus Maryland, which is a little bit of a strange connection, I realize, except that Marshall and McCulloch I love that he's giving this as the positive case for federal power. And so he says something like, from the St. Croix to the Gulf of Mexico, armies are to be marched and revenues are to be collected. And it's an interesting, you know, wow, everybody can rally behind that, armies and taxes. But I think that's very Jacksonian in a strange way. Like, again, in the sort of Constitution as an anchor for this very underspecified, disparate nation, and then also Jackson and sort of what he stands for in terms of kind of symbol of the nation and military strength. And then 2 chapters in the book talk about especially the Cherokee Constitution and the Cherokee political controversies. Jackson's a big figure there for obvious reasons. And just the way that he, you know, is sort of at one level this very hardline national power person when it comes to, say, responding to South Carolina and nullification. And on the other hand, in the Cherokee removal scenario, he's sort of is perfectly willing to kind of say, it's beyond my control, how could I possibly stop Georgia? Even while at the same time, he and his emissaries are telling Georgia, essentially, you can expropriate land, you can go and take Cherokee and other indigenous nations' land. So he's there, but I think decentering him from being the actor who kind of sets it all in motion is important to me. Yes?
I have a question about your process of writing the book and I guess legal history in general. How important are the arguments that you phrased at the beginning or you articulated at the beginning of your talk? How important are those arguments to your work versus just the value of making more information available for everybody to learn from? Because that seems like it has a lot of value in itself. So I guess, yeah, how do you see then constructing the arguments as part of your work as well?
Yeah. It's a great question. It's something I like to think about a lot. I mean, I think first is when you're doing legal history, you spend a lot of time reading a lot of things, not quite knowing what the argument is going to be. And so reading microfilm, documents, people's handwriting. I mean, I love reading people's handwriting, but it's not to everybody's taste. But I think very much for me, it's a book that's driven, the project is driven by the history. So it's a kind of, I'm not trying to find the origins of something today that will be explained by something then, or like a perfect mirror. So one of the things I've said, and some people in this room have heard me say this before, is legal history, the questions are necessarily shaped by today whenever we're writing, but the answers shouldn't be, which is always, of course, a struggle, right? Because how do you make sure that you're not doing that? But then again, I think I also teach constitutional law, and federalism is clearly something that's very much in sort of the forefront of public debates. So while I wouldn't say there's a direct parallel or a lesson for any of these episodes, I think there are suggestive lessons and a lot of the time correctives. And I think there's also a methodological or interpretive corrective to the extent that we hear from, say, the Supreme Court that they're interested in a certain version of history and tradition, and that they're interested in the founding, and now they're interested in Reconstruction. I would say to them, well, you should be interested in what comes in between as well, because it's actually quite different, and you're going to miss the historical meaning that you are so eager to find if you skip over this long period. So that's where I would see the kind of normative interpretive arguments coming from, but based on the kind of strong foundation of the historical research, because that's, to me, that's the really fun stuff. Reading other people's letters. It's great. Yes, boom.
Thank you for this. I'm really excited for the book to come out later this month. My question is sort of about so a lot of the historiography that you talked about sort of marries an account of constitutional ideology with like socioeconomic factors. And I think that in your talk here, you pretty effectively demolished the idea that like within South Carolina, there are people from similar social backgrounds who have opposite constitutional ideologies. But then I'm wondering, are there new sort of underlying patterns for these constitutional groupings that you've seen over the course of the research, or is this an account in which like ideology is sort of like the prime mover in and of itself?
That's really interesting. So I guess one other groupings that I found, not so much in this chapter and then what I just presented, but sort of throughout the book, are the vast number of people who are kind of neither northern nor southern in the way, again, that those get described sort of Civil War and after, and how prominent a lot of those people are in the constitutional and political debates of this period. So, for instance, the Supreme Court bar, which is all these people who are kind of, speaking for 4 and 5 hours at a time, and they're these kind of preening, oratorical, kind of political theorist types. Many of them are from Maryland and Virginia. And to me, that's quite interesting, that they're from these sort of, what later will be called border states. They're not from deep southern states, they're from states that are kind of adjacent to, say, Washington, D.C., but Virginia has its own, obviously, long political legacy and sense of itself. And then you start to bring in the Westerners too, so the Ohioans and other folks. So I think, again, there's a kind of, sometimes for this period, there's a reductive sense of, well, because this person was from the North or the South. Now, first of all, what does that even mean? Like when you're talking about, say, Maryland or Missouri or something in this period. But second of all, I think a lot of those sort of border-ish folks have a very distinctive view. And some of them, I mean, it's not a uniform view, but they are, Roger Taney's from Maryland, William Wirt is from Maryland, I mean, on and on through the Supreme Court bar. Some of them move around. So I think that's a kind of part of this set of people that may have this sensibility. I mean, it kind of goes to, are they of their state or are they of the nation? You also see these people moving in and out of institutions and offices in government where they don't seem to have that sense of like, I'm a state person, you're a federal person. So I think those are all kind of aspects of not so much biography, but definitely kind of like groups and an ideology formation story about groups of people who are in dialogue with each other that we maybe haven't attended to as much as we should. One more question. Sarah?
It's about commerce. I
Yes.
am wondering why you, maybe what motivated the Commerce Clause to be the vessel into which these conflicts of federalism are poured into. I think that in your response to Professor Pinnell, there's sort of an intuitive answer, which is just that there's like these local federal conflicts occurring in port cities or sort of in these areas of dispute, which then easily lend themselves to the Commerce Clause being the center point. But I'm wondering if like that, not necessarily the simplistic answer, but sort of intuitive answer is the only motivation, or do you think there's something more going on as well?
Yeah. I think it goes back, I think there's more to the answer, and some of it goes back to the Scottish Enlightenment and sort of political theory, when some of these people, meaning drafters of, say, the Constitution and the Articles of Confederation, are writing. I mean, I think they really have this vision of commerce as interchange and interaction, and it will have these positive societal benefits. Like Adam Smith in Theory of Moral Sentiments, it's not just commerce and markets, Pache, our law school. It's commerce and kind of sympathy and the impartial spectator, which gets people to behave better, also our law school. And so it's kind of, I mean, the phrase they use is doux commerce, sweet and gentle commerce. So it is both commerce in the sense of trade, which I think lends itself to this, well, that's where all the debates happen, and that's where people care about stuff, and there's money, and there's exchange, and all these parties. But I think they also have a sense that commerce has this kind of bigger quality to it. And so why do they then bury it in not the first clause of, Article 8? I mean, the questions about how they draft the Constitution are sort of separate. But I think the notion of commerce as not only a term of art in constitutional law, but that it has this political theory and sort of how you organize a society kind of connotation, to me, is a part of why this becomes such a defining point for them. Thank you.
Thank you, everybody, for coming. And I want to again express my thanks to the Fulton family for the opportunity for us to gather today. And please join me again in thanking our 2024 Fulton lecturer, Professor Alison LaCroix.
Thank you.